Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Axon Enterprise Incorporated v. Federal Trade Commission. In this case, the court considered this issue. Do federal courts have jurisdiction to hear constitutional challenges to the Federal Trade Commission structure, procedure, and existence, or must such challenges be raised first in the administrative proceeding? The case was decided on April 14, 2023. The Supreme Court held that federal courts have federal question jurisdiction to hear constitutional challenges. The structure or existence of the SEC or FTC, notwithstanding statutory review schemes, set out in the Securities Exchange Act and Federal Trade Commission Act. Justice Elena Kagan authored the majority opinion holding that the Federal Trade Commission Act, in 21-86, and the Securities Exchange Act, in 21-1239, did not preclude district courts' ordinary subject matter jurisdiction to hear challenges to those agencies' structure, procedure, or existence. The court considered three factors, known as the Thunder Basin factors, to determine whether particular claims concerning agency action are of the type Congress intended to be reviewed within the statutory structure, and thus would preclude district court jurisdiction. The three factors are: 1. Could precluding district court jurisdiction foreclose all meaningful judicial review of the claim? 2. Is the claim wholly collateral to the statute's review provisions? 3. Is the claim outside the agency's expertise? The court concluded that all three factors supported the conclusion that district courts retained subject matter jurisdiction. First, preclusion of district court jurisdiction could foreclose all meaningful judicial review, because Axon and Cochran will lose their rights not to undergo the complaint of agency proceedings if they cannot assert those rights until the proceedings are over. Second, the claims are wholly collateral to the statute's review provisions because challenges to the Commission's authority have nothing to do with either the enforcement-related matters the Commissions regularly adjudicate, or those they would adjudicate in assessing the charges against Axon and Cochran. Finally, the claims are outside the agency's expertise, because neither specializes in constitutional issues like separation of powers. Justice Clarence Thomas authored a concurring opinion to express grave doubts about the constitutional propriety of Congress vesting administrative agencies with primary authority to adjudicate core private rights with only deferential judicial review on the back end. Justice Neil Gorsuch authored an opinion concurring in the judgment, arguing that he would reach the same conclusion as the majority by applying only 28 U.S.C. Section 1331, which establishes federal question jurisdiction of federal courts. The opinion is presented here in its entirety but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kagan delivered the opinion of the court. In each of these two cases, the respondent in an administrative enforcement action challenges the constitutional authority of the agency to proceed. Both respondents claim that the agency's administrative law judges, ALJs, are insufficiently accountable to the President, in violation of separation of powers principles, and one respondent attacks as well the combination of prosecutorial and adjudicatory functions in a single agency. The challenges are fundamental, even existential. They maintain in essence that the agencies, as currently structured, are unconstitutional in much of their work. Our task today is not to resolve those challenges, rather, it is to decide where they may be heard. The enforcement actions at issue were initiated in the Securities and Exchange Commission, SEC, and the Federal Trade Commission, FTC. Most objections to those commissions' proceedings follow a well-trod path. As prescribed by statute, a party makes its claims first within the commission itself, and then, if needed, in a federal court of appeals. The parties here, however, sidestepped that review scheme. Seeking to stop the administrative proceedings, they instead brought their claims in federal district court. The question presented is whether the district courts have jurisdiction to hear those suits, and so to resolve the parties' constitutional challenges to the commission structure. The answer is yes. The ordinary statutory review scheme does not preclude a district court from entertaining these extraordinary claims. Congress established the SEC to protect investors in securities markets, and created the FTC to promote fair competition. The commissions enforce respectively the Securities Exchange Act and the FTC Act, among other laws. Those acts authorize the commissions to address statutory violations either by bringing civil suits in federal district court, or by instituting their own administrative proceedings. When a commission elects the latter option, as in these two cases, it typically delegates the initial adjudication to an ALJ. To foster independence, each commission's ALJs are removable only for good cause as determined by the Merit Systems Protection Board, MSPB, a separate agency whose members are themselves removable by the President only for cause, such as neglect of duty or malfeasance. An ALJ assigned to hear an SEC or FTC enforcement action has authority, much like a regular trial judge, to resolve motions, hold a hearing, and then issue a decision. A losing party may appeal the ALJ's ruling to the Commission. Alternatively, the Commission may undertake review on its own initiative. Upon completion of internal review, the Commission enters a final decision. Or if no such review has occurred, the ALJ's ruling itself becomes the decision of the Commission. The Exchange Act and FTC Act both provide for review of a final Commission decision in a court of appeals, rather than a district court. Under the Exchange Act, a person aggrieved by an SEC final order may obtain review of the order by filing a petition in a court of appeals. That petition gives the appellate court jurisdiction to affirm or modify and enforce or to set aside the order in whole or in part. The FTC Act similarly provides that the parties subject to an FTC order may obtain a review of such order in a court of appeals, and grants the court jurisdiction to affirm, modify, or set aside the order. The cases before us, though, did not take the above-described course. In each, the respondent in an administrative enforcement action sued in district court prior to an ALJ decision, seeking to enjoin the Commission's proceeding. Each suit charged that some fundamental aspect of the Commission's structure violate the Constitution, that the violation made the entire proceeding unlawful, and that being subjected to such an illegitimate proceeding causes legal injury, independent of any rulings the ALJ might make. Finally, each suit premised jurisdiction on district court's ordinary federal question authority, their power, under 28 U.S.C. Section 1331, to resolve civil actions arising under the Constitution, laws, or treaties of the United States. We describe the two cases in turn, but what we have just said they have in common is really all it is necessary to know. The first case arises from an SEC enforcement action brought against Michelle Cochran, a certified public accountant. In an earlier round of that proceeding, an ALJ found that Cochran had failed to comply with auditing standards, in violation of the Exchange Act. But soon after that decision issued, this court held that the SEC's ALJs had been improperly appointed. In compliance with that ruling, the SEC ordered a fresh hearing, conducted by a now validly appointed ALJ. That was the last straw for Cochran. Before the new ALJ hearing began, she sued the Commission in federal district court, asserting jurisdiction under Section 1331. Cochran's complaint focused on the two layers of tenure protection all ALJs hold, by statute. Those officials may be removed only for good cause, as determined by the MSPB, whose members themselves can only be removed by the President for good cause. That arrangement, Cochran asserted, so greatly insulates ALJs from presidential supervision as to violate the separation of powers, more specifically, Article 2's vesting of executive power in the President. And because that was true, Cochran continued, ALJs could not constitutionally exercise power. They could neither hold any hearings nor make any decisions. Cochran thus sought declaratory and injunctive relief, freeing her of the obligation to submit to an unconstitutional proceeding. The second case arises from an FTC enforcement action against Axon Enterprise, a company that makes and sells policing equipment. In its complaint, the FTC alleged that Axon's purchase of its closest competitor violated the FTC Act's ban on unfair methods of competition. To stop the FTC from pursuing that charge, Axon did just what Cochran had, brought suit against the Commission in district court, premised on federal question jurisdiction. Like Cochran, Axon asserted that the Commission's ALJs could not constitutionally exercise governmental authority because of their dual-layer protection from removal. In addition, Axon claimed that the combination of prosecutorial and adjudicative functions in the Commission renders all of its enforcement actions unconstitutional. Again, similarly to Cochran, Axon asked the court to enjoin the FTC from subjecting it to the Commission's unfair and unconstitutional internal forum. Cochran's and Axon's suits met an identical fate in district court, dismissal for lack of jurisdiction. The district court in Cochran's case held that the review scheme specified in the Exchange Act, administrative review followed by judicial review in a federal court of appeals, implicitly divests district courts of jurisdiction over challenges to SEC proceedings, including Cochran's constitutional ones. Likewise, the district court, in Axon's case, found that the FTC Act's comparable review scheme displaces Section 1331 jurisdiction for claims concerning the FTC's adjudications. So Axon had to raise its structural constitutional claims during the administrative process, and then renew them if and when seeking review in the Court of Appeals. On appeal from those decisions, the United States Courts of Appeals for the Fifth and Ninth Circuits split. The Ninth Circuit, considering Axon's case, reached the same conclusion as the district courts. Reviewing this court's precedents, the Ninth Circuit acknowledged that a statutory review scheme precluding district court jurisdiction, like the FTC Acts, might not extend to every type of claim. But the court decided that Axon's constitutional challenges fell within the FTC Act scheme, mainly because the scheme guaranteed them meaningful judicial review. The en banc Fifth Circuit disagreed as to the equivalent SEC question. The court maintained that Cochran's removal power claim is not the type of claim Congress intended to funnel through the Exchange Act's statutory review scheme. Drawing on considerations identified in this court's opinions, the Fifth Circuit reasoned that Cochran's claim would not receive meaningful judicial review in a court of appeals, that the claim was wholly collateral to the Exchange Act's statutory review scheme, and that the claim fell outside the SEC's expertise. We granted certiorari in both cases to resolve the division. We now conclude that the review schemes set out in the Exchange Act and the FTC Act do not displace district court jurisdiction over Axon's and Cochran's far-reaching constitutional claims. A special statutory review scheme, this court has recognized, may preclude district courts from exercising jurisdiction over challenges to federal agency action. District courts may ordinarily hear those challenges by way of 28 U.S.C. Section 1331's grant of jurisdiction for claims arising under federal law. Congress, though, may substitute for that district court authority an alternative scheme of review. Congress, of course, may do so explicitly, providing in so many words that district court jurisdiction will yield. But Congress also may do so implicitly, by specifying a different method to resolve claims about agency action. The method Congress typically chooses is the one used in both the Exchange Act and the FTC Act: review in a court of appeals following the agency's own review process. We have several times held that the creation of such a review scheme for agency action divests district courts of their ordinary jurisdiction over the covered cases. The agency effectively fills in for the district court, with the Court of Appeals providing judicial review. But a statutory review scheme of that kind does not necessarily extend to every claim concerning agency action. Our decision in Thunder Basin made that point clear. After finding that Congress's creation of a comprehensive review process like the ones here ousted district courts of jurisdiction, the court asked another question: whether the particular claims brought were of the type Congress intended to be reviewed within this statutory structure. The court identified three considerations designed to aid in that inquiry, commonly known now as the Thunder Basin factors. First, could precluding district court jurisdiction foreclose all meaningful judicial review of the claim? Second, is the claim wholly collateral to the statute's review provisions? And third, is the claim outside the agency's expertise? If, but only if, the answers to those questions are yes, then a court may find in a suit like Cochran's or Axon's that it retains district court jurisdiction to resolve the claim. The claim is unlikely to fall within the scope of the review scheme, because it is of the type Congress would not have intended to be channeled in that way. Two subsequent cases shed light on how to apply the Thunder Basin framework. In Free Enterprise Fund, the plaintiffs brought a constitutional challenge to the creation and composition of the Public Company Accounting Oversight Board. The plaintiffs could eventually have raised their challenge to board action by seeking review in a court of appeals, but they instead filed suit in federal district court, and this court found the action proper. The court explained that the plaintiff's claim, like the claims here, was collateral to any ordinary statutory review scheme, because it neither challenged any board rule or report nor sought to enjoin any board order. The claim was outside the Commission's competence and expertise, because it raised standard questions of administrative law that the courts are more than capable of answering. And finally, the claim was one that in practical terms could not receive meaningful judicial review in a court of appeals, because of the bureaucratic mazes a party would have to negotiate before reaching such a court. Those hurdles included not only an administrative hearing and full Commission review, but also a sanctions requirement. A party could obtain judicial review only by subjecting itself to a board enforcement action that might lead to severe punishment. In Elgin v. Department of Treasury, the plaintiffs brought a constitutional challenge to their dismissal from federal employment. This court held that Congress's creation of a detailed review scheme for employment-related actions precluded district court jurisdiction. Two Thunder Basin factors were sufficient to decide the case. First, the plaintiffs' claims were not collateral to the administrative scheme, because they related to the very subject matter the statute provided for review, personnel actions that an administrative body could order removed. Second, those claims were not outside the agency's expertise, because the agency routinely considers similar constitutional questions. So the court did not see how the plaintiffs could gain anything by going first to district court. Indeed, the only way the Thunder Basin factors stacked up in the plaintiffs' favor was that they were sure to receive judicial review of their claims in due course. But still the court thought the answer clear. Because Congress had established an exclusive method for reviewing the agency's personnel actions, the plaintiffs had to proceed in accordance with the statutory scheme. The district court had to step aside. Applying the Thunder Basin factors, we find that Axon's and Cochran's claims are not the type that Congress meant to be channeled through the Exchange Act or FTC Act review schemes. The district courts thus retain jurisdiction to adjudicate those claims. First and foremost, the constitutional claims here are, as in Free Enterprise Fund, collateral to any commission orders or rules from which review might be sought. Indeed, the claims are akin to the one the plaintiff there made. Axon's and Cochrane's claims, like the free enterprise funds, challenge the Commission's power to proceed at all, rather than actions taken in the agency proceedings. The plaintiffs assert not that a Commission decision violates some, lower-level, legal right, but rather that the structure or even existence of an agency violates the Constitution. Their claims thus do not relate to the subject of the enforcement actions, in Free Enterprise Fund. Alleged violations of the Sarbanes-Oxley Act, in Axon's case, alleged violations of the FTC Act, in Cochrane's, alleged violations of the Exchange Act. They are instead collateral to any Commission orders or rules from which review might be sought. Axon's and Cochrane's claims are also outside the Commission's expertise. The constitutional questions presented here are fundamental, even existential. They concern not the unlawfulness of any specific agency action, but whether the agencies, as currently structured, have constitutional authority to act at all. The ALJs have no special qualifications in this area. They are not experts on the separation of powers, nor do they have any particular expertise in interpreting the Constitution. Indeed, the whole point of the claim is that A.L.J.Z.'s existence and authority is unconstitutional, and they have no competence to decide such an issue. Finally, meaningful judicial review of Axon's and Cochrane's claims would be practically unavailable. The constitutional injury that the plaintiffs allege is the very act of being subjected to an illegitimate proceeding. They assert a right not to undergo the proceedings at all, and thus, the review that the statutes provide only after a proceeding's conclusion does not offer a meaningful opportunity to resolve their claims. This situation differs from that in Elgin, where the claimants were guaranteed judicial review of their constitutional challenge as part of the statutory scheme. Here, by contrast, the entire proceeding might be found illegitimate, and requiring parties to go through such a process would cause irreparable harm. In conclusion, Axon's and Cochrane's constitutional claims fall outside the bounds of the statutory review schemes in the Exchange Act and the FTC Act. They raise fundamental constitutional questions that are collateral to the subject matter of the enforcement actions, are beyond the expertise of the ALJs, and would not receive meaningful judicial review through the statutory schemes. Therefore, the district courts have jurisdiction to hear their claims. The judgments of the Fifth and Ninth Circuits are reversed, and the cases are remanded for further proceedings consistent with this opinion. It is so ordered. Justice Thomas, concurring. I join the Court's opinion, in full, because it correctly applies precedent to determine that Axon Enterprises and Michelle Cochrane's structural constitutional claims need not be channeled through the administrative review schemes at issue. I write separately, however, because I have grave doubts about the constitutional propriety of Congress vesting administrative agencies with primary authority to adjudicate core private rights with only deferential judicial review on the back end. The Court correctly notes that precedent allows Congress to replace Article III district courts with an alternative scheme of review, as it did in the provisions of the Securities Exchange Act and the Federal Trade Commission Act at issue here. Under such schemes, administrative agencies may impose orders and penalties on private parties, adjudicate them before agency administrative law judges, ALJs, and only then be subjected to deferential review by an Article III court. As the Court puts it, the agency effectively fills in for the district court, with the Court of Appeals providing judicial review. That Article III review is sharply limited. For example, under the administrative review schemes at issue here, the reviewing court must treat agency findings of fact as conclusive so long as they are supported by substantial evidence, a highly deferential standard of review. The reviewing court also cannot take its own evidence, it can only remand the case to the agency for further proceedings. This mixed system, primary adjudication by an executive agency subject to only limited Article III review, is unlike the system that prevailed for the first century of our nation's existence. During that period, judicial review was all or nothing. Either a court had authority to review administrative action or not, and if it did, it decided the whole case. This all-or-nothing model rested on a conceptual distinction between core private rights on the one hand, and mere public rights and governmental privileges on the other. Disposition of private rights to life, liberty, and property was understood to fall within the core of the judicial power, whereas disposition of public rights was not. Thus, the measure of judicial involvement was private right. In particular, the extent to which the judiciary reviewed actions and legal determinations of the executive depended on private right. Even today, the distinction between public rights and private rights continues to inform this Court's understanding of Article III judicial power. As I have explained, when private rights are at stake, full Article III adjudication is likely required. Private rights encompass the three absolute rights: life, liberty, and property, so called because they appertain and belong to particular men merely as individuals, not to them as members of society or standing in various relations to each other, that is, not dependent upon the will of the government. Such rights could be adjudicated and divested only by Article III courts. A different regime prevailed for public rights and privileges. Unlike the private unalienable rights of each individual, Public rights belong to the people at large, and governmental privileges are created purely for reasons of public policy, and have no counterpart in the Lockean state of nature. It was understood at the founding that such governmental privileges, some of which we today call government benefits and entitlements, could be taken away without judicial process. Thus, the legislative and executive branches may dispose of public rights and privileges at will, including through non-Article 3 adjudications. The requirement of plenary Article 3 adjudication of private rights began to change in the early 20th century. As notions of administrative efficiency came into vogue, courts were viewed less as guardians of core private rights, and more as impediments to expert administrative adjudication. After his election in 1904, President Theodore Roosevelt, who shared the progressive faith in administrative expertise, sought to rein in judicial review of administrative action. This progressive sentiment led to the Hepburn Act, which was designed to curb judicial review of Interstate Commerce Commission (ICC) rate orders. Prior to the Hepburn Act, the ICC was required to file a bill of equity in court to obtain judicial enforcement of its rate orders. But the Hepburn Act provided that the ICC's orders were to be self-executing 30 days after they became final, unless suspended or set aside by a court of competent jurisdiction, almost inverting the traditional system. While the Act was silent on the standard of review, this court understood the implied threat that if it did not back off from its aggressive review practices, more drastic action would be in the offing. Accordingly, the court began to develop what is now known as the appellate review model. While maintaining that the courts must decide all relevant questions of constitutional power or right and other questions of law, the court held that an ICC order supported by evidence must be accepted as final. Following the court's lead, Congress codified the appellate review model in the two statutes at issue here. The Federal Trade Commission Act provided that the findings of the Commission as to the facts, if supported by testimony, shall in like manner be conclusive in federal court. The Securities Exchange Act of 1934 likewise provided that the SEC's findings shall be conclusive if supported by substantial evidence. In the 1930s, this court upheld the constitutionality of the appellate review model against arguments that it violated the separation of powers and Seventh Amendment. First, in Kroll v. Benson, the court examined the Longshoremen's and Harbor Workers' Compensation Act, which authorized administrative agencies to adjudicate workers' compensation claims against private parties. The court acknowledged that the case was one of private right, but held that Congress had the authority to place primary fact-finding authority in an administrative agency. It reasoned that such a scheme did not violate Article 3, because Congress has considerable power to structure judicial proceedings and to regulate the mechanisms that courts use to ascertain facts. Next, in NLRB v. Jones and Laughlin Steel Corporation, the court examined the National Labor Relations Act's judicial review provisions, which required an Article 3 court to accept the National Labor Relations Board's factual findings, so long as they were supported by evidence in the administrative record. The court held that this arrangement did not violate the Seventh Amendment, which provides that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. The court reasoned that, because claims seeking statutory remedies for violations of the Act were statutory proceedings that were unknown to the common law, they were not suits at common law within the meaning of the Seventh Amendment. These cases solidified administrative agencies' authority to act as fact-finding adjuncts to the federal judiciary on a broad array of statutory claims, including claims for monetary relief. As I have previously explained, because federal administrative agencies are part of the executive branch, it is not clear that they have power to adjudicate claims involving core private rights. The appellate review model of agency adjudication thus raises serious constitutional concerns. It may violate the separation of powers by placing adjudicatory authority over core private rights, a judicial rather than executive power, within the authority of Article 2 agencies. It may violate Article 3 by compelling the judiciary to defer to administrative agencies regarding matters within the core of the judicial vesting clause. And it may violate due process by empowering entities that are not courts of competent jurisdiction to deprive citizens of core private rights. Finally, the appellate review model may run afoul of the Seventh Amendment by allowing an administrative agency to adjudicate what may be core private rights without a jury. It is no answer that an Article 3 court may eventually review the agency order and its factual findings under a deferential standard of review. In fact, there seems to be no basis for treating fact-finding differently from deciding questions of law. Both are at the core of judicial power, as Article 3 itself acknowledges. For much of the nation's history, it was understood that Article 3 precluded the political branches from exercising power over the determination of individualized adjudicative facts when core private rights were at stake. It is obvious that Article 3 would not be satisfied if Congress provided for judicial review, but ordered the courts to affirm the agency no matter what. And T here is no reason to think that it is any different if Congress instead simply orders courts to put a thumb, or perhaps two forearms on the agency's side of the scale. Such a regime allows a mere party to supplant a jury as the court's fact-finder. Hamburger 319, and it effectively vests the judicial power either in the agency or in Congress. It thus appears likely that, when agency adjudicators stray outside the proper limits of executive adjudication, such as by depriving individuals of vested property rights, they must not serve even as fact-finders subject to judicial deference. In sum, whether any form of administrative adjudication is constitutionally permissible likely turns on the nature of the right in question. If private rights are at stake, the Constitution likely requires plenary Article 3 adjudication. Conversely, if privileges or public rights are at stake, Congress likely can foreclose judicial review at will. The rights at issue in these cases appear to be core private rights that must be adjudicated by Article 3 courts. For one, Axon and Cochran face the threat of significant monetary fines. Indeed, in the first round of proceedings, the SEC imposed a $22,500 civil penalty on Cochran. And the FTC seeks to require Axon to transfer intellectual property to another entity. These types of penalties and orders implicate the core private right to property. Accordingly, they likely must be adjudicated by Article 3 courts and juries. Naturally, merely labeling the deprivation of a core private right a civil penalty cannot allow Congress and agencies to circumvent constitutional requirements. By permitting administrative agencies to adjudicate what may be core private rights, the administrative review schemes here raise serious constitutional issues. Because the court today correctly holds that Axon's and Cochran's claims are not precluded by the review channeling provisions at issue here, I join its opinion in full. In an appropriate case, we should consider whether such schemes and the appellate review model they embody are constitutional methods for the adjudication of private rights. Justice Gorsuch, concurring in judgment, I agree with the court that Michelle Cochran and Axon Enterprise are entitled to their day in court, but to my mind the reason why has nothing to do with the Thunder Basin factors. Instead, it follows directly from 28 U.S.C. Section 1331. The Constitution vests in Congress the power to create and organize lower federal courts. Exercising that power, for the last 150 years Congress has afforded lower federal courts jurisdiction to hear civil disputes arising under the Constitution or laws of the United States. Today, Section 1331 provides that district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Not may have jurisdiction, but shall. Not some civil actions arising under federal law, but all. The statute is as clear as statutes get, and everyone agrees it encompasses the claims Ms. Cochran and Axon seek to pursue. End of case, right? Not so fast. As the court sees it, Ms. Cochran, Axon, and others like them must satisfy not only Section 1331, they must also satisfy a judge-made, multi-factor balancing test, one assembled from remarks scattered here and there across the pages of Thunder Basin Coal Company v. Reich, and one, we are told, designed to ferret out whether the legislators who adopted the Federal Trade Commission Act in 1914 and the Securities Exchange Act in 1934 harbored an implicit wish to oust district courts of jurisdiction in favor of agency proceedings. So, yes, the law on the books may promise you the right to be heard in a court of law, but sometimes that doesn't count for much. Sometimes judges can shunt you to an agency instead, so long as a test we have fabricated suggests to us that is what Congress really wanted. There are many problems with the Thunder Basin project, but start with its sheer incoherence. At the outset, Thunder Basin requires litigants and courts to ask whether a comprehensive review process exists. What does that mean? It seems a review process will typically qualify as comprehensive when review in a court of appeals follows the agency's own review, but typically does not mean necessarily. Just because an agency can hear a case does not mean a district court cannot. To decide whether a particular case belongs in an agency rather than a court, you must consult three further considerations, commonly known now as the Thunder Basin factors. That's where the magic happens. The Thunder Basin factors require assessing whether 1. Precluding district court jurisdiction would foreclose all meaningful judicial review. 2. The plaintiff's claims are wholly collateral to the statutory review scheme. And 3. The claims are outside the agency's expertise. Harnessing the energy of these various factors, we are assured will allow anyone to detect a latent congressional intent to oust district courts of their jurisdiction in any given case. Just see how easy it is. To apply the first factor, all you have to do is ask a few more questions. They include whether the plaintiff could eventually obtain review in some federal court, whether that court's review would come too late to be meaningful, and, maybe, how analogous the plaintiff's plea for immediate review is to a governmental official's plea for qualified immunity. If this is starting to seem more confounding than clarifying, do not worry. The first factor is the least straightforward anyway. When it comes to the second factor, you only need to evaluate the collateralism of the plaintiff's claim. Apparently, That requires considering the nature of the claim, not the status, pending or not, of an agency proceeding. The third factor is just one easy question too, focused on whether the plaintiff's claim is intertwined with or embedded in matters on which the agency is expert. If that does not help, try asking if the claim is entangled with the agency's expertise, or if the agency can bring to bear distinctive knowledge. Even after you make it through these twists and turns, a final surprise sometimes awaits. The court holds that all three Thunder Basin factors favor Ms. Cochran and Axon, so their cases may proceed in district court. But what happens when the factors point in different directions, some in favor and others against immediate judicial review? No one knows. You get to guess. Putting aside these problems with the Thunder Basin project serves only to expose others. We are told that consulting so many disparate factors is essential if we are to divine and give effect to implicit congressional intentions to divest district courts of jurisdiction in favor of certain agency proceedings. But what gives courts authority to engage in this business of jurisdiction stripping by implication? The answer, of course, is nothing. Under our Constitution, Congress, and not the judiciary, defines the scope of federal jurisdiction. Federal courts have no more right to decline the exercise of jurisdiction which is given, than to usurp that which is not given. That is why we have called it the true rule that statutes clearly defining the jurisdiction of the courts must control, in the absence of subsequent legislation equally express, and why we have said that jurisdiction conferred by 28 U.S.C. Section 1331, in particular, should hold firm against mere implications from other laws. Thunder Basin defies these foundational rules. Maybe worse, it exhibits familiarity with none of them. No one disputes that Section 1331 represents a valid exercise of Congress's authority to regulate the jurisdiction of the district courts. No one questions that Section 1331 permits cases like those before us to proceed. No member of the court points to any statute Congress has adopted that speaks otherwise. Under the law, that should be the end of the matter. But under Thunder Basin, courts may refuse individuals their right to a judicial forum based on nothing more than suppositions about implicit congressional intentions. Divesting jurisdiction by mere implication goes from out of bounds to the name of the game. Along the way, this court arrogates to itself a power to control the jurisdiction of lower federal courts that the Constitution reserves to Congress. All to what end? At bottom, Thunder Basin rests on a view that it is sometimes more important to allow agencies to work without the bother of having to answer suits against them than it is to allow individuals their day in court. But when Congress holds that view, it does not ask us to juggle a variety of factors and then guess at the implicit intentions of legislators past. It simply tells us, 3. There is a better way. Our job is to interpret the laws Congress has adopted. It is a task that begins with the language of the relevant statutes, and when the statutory language provides a clear answer, it ends there as well. Because no one doubts that Section 1331 vests district courts with jurisdiction to hear these cases, the only question properly before us is whether Congress has actually carved out some exception in some other statute. The government points to 2 candidates, but the government's arguments from those laws are so improbable that the court barely mentions them. I pause to walk through each only to illustrate how these cases should have been resolved. In Ms. Cochran's case, the government directs our attention to Section 78(1) of the Exchange Act. That provision says that a person aggrieved by a final order of the Commission may obtain review of the order in the United States Court of Appeals by filing in such court a written petition requesting that the order be modified or set aside in whole or in part. Plainly, the statute promises jurisdiction in a court of appeals for those hoping to contest a final order of the Commission. But just as plainly, Ms. Cochran does not seek to challenge an SEC final order, nor could she, because the agency has not entered one in her case. Ms. Cochran does not even seek relief in anticipation of a final agency order. Instead, she seeks to avoid being hauled before an agency that she alleges is unconstitutionally structured. That is exactly the kind of here-and-now injury this court has held can be remedied by a court without regard to the eventual outcome of agency proceedings. If all that were not enough, there is more. A neighboring statutory provision says that the rights and remedies the Exchange Act authorizes shall be in addition to any and all other rights and remedies that may exist at law or in equity. This court has explained that a saving clause of this sort strongly buttresses the conclusion that a review provision such as Section 78(1) does not preclude traditional avenues of judicial relief. And, of course, one traditional avenue of relief is a suit in district court under Section 1331 seeking to enjoin unconstitutional conduct. Far from barring Ms. Cochran's path to court then, the Exchange Act expressly preserves it. The story repeats itself when it comes to Axon. The government insists that Section 5C of the FTC Act precludes district courts from entertaining constitutional challenges to the agency's structure. But Section 5C provides only that parties subject to an order of the Commission to cease and desist from using any method of competition or act or practice may obtain a review of such order in the Court of Appeals of the United States. And, here again, we have nothing like that. The FTC has not ordered Axon to cease and desist from anything. That Section 5C does not foreclose Axon's case finds reinforcement next door to. Section 5D holds that, upon the filing of the record, the jurisdiction of the Court of Appeals of the United States to affirm, enforce, modify, or set aside orders of the Commission shall be exclusive. So until an administrative record is lodged in the Court of Appeals, something that hasn't happened here either, the appellate court's jurisdiction is not exclusive, and a plaintiff like Axon remains free to proceed in district court. In both cases, the relevant statutes guide the way. Section 1331 grants district courts the power to hear Ms. Cochran's and Axon's claims, and no other law takes that power away. Resolving jurisdictional disputes by looking to the terms of the statutes Congress has adopted may hold none of the suspense that comes with a ride on the Thunder Basin roller coaster. But that is as it should be. Where the statutory language is clear, our sole function is to enforce it according to its terms. While the court reaches the right result today, its choice of the wrong path matters, not just because continuing to apply the Thunder Basin factors leaves the law badly distorted. It also matters because Thunder Basins throw it in a blender approach to jurisdiction imposes serious and needless costs on litigants and lower courts alike. Jurisdictional rules, this court has often said, should be clear and easy to apply. For parties, complex jurisdictional tests complicate a case, eating up time and money as they litigate, not the merits of their claims, but which court is the right court to decide those claims. For courts, jurisdictional rules mark the bounds of their adjudicatory authority. Judges therefore benefit from straightforward rules under which they can readily assure themselves of their power to hear a case, while adventitious rules leave them with almost impossible tasks to perform that squander their limited resources. There are many words to describe the Thunder Basin factors, but clear and easy to apply are not among them. To appreciate the trouble Thunder Basin can generate for litigants and lower courts alike, consider some of the facts of Ms. Cochran's case that do not find their way into the court's opinion. A single mother of two and a certified public accountant, Ms. Cochran began looking for part-time work in 2007. Eventually, she found a position at a small company called the Hall Group. Soon, however, she discovered that the owner, David Hall, was not just abrasive but dishonest. At one point, he even added Ms. Cochran's name to the firm's business license without her permission, all to facilitate his idea of rebranding his company as the Hall Group CPAZ. When Ms. Cochran protested, Mr. Hall offered her a choice: become a non-equity partner with no increase in pay so that he could use the new name or leave the firm. Ms. Cochran chose to quit and put the whole ordeal behind her, or so she thought. Years later, in 2016, Ms. Cochran learned that the SEC had initiated an enforcement proceeding against Mr. Hall, another of his former employees, and herself. The SEC charged Ms. Cochran with violating Rule 2-02b. 1. Of Regulation SX and Section 13A of the Securities Exchange Act, 1934 and Rules 13A1 and 13A13 thereunder, as well as aiding and abetting, Rule 2-02b. 1, violations. In English, the SEC alleged that Ms. Cochran had failed to complete auditing checklists, leaving certain sections of certain forms blank. The agency brought these charges even though there was no evidence that the incomplete paperwork had resulted in any monetary harm to clients or investors. The SEC elected to proceed against Ms. Cochran before its own internal tribunal rather than, as it could have, a court of law. The agency assigned the case to one of its hearing officers, an administrative law judge or ALJ. Reportedly, that ALJ made a practice of warning defendants during settlement discussions that he had never ruled against the agency's enforcement division. It seems, though, Ms. Cochran didn't take the hint. She refused to settle and sought to represent herself in the hearing that followed. It did not go well. Just as her hearing was about to start, her former boss settled his own case and then turned about to testify against Ms. Cochran. In the end, the ALJ fined Ms. Cochran $22,500 and banned her from practicing before the SEC as an accountant for at least 5 years. Ms. Cochran responded by asking the full commission to review the ALJ's decision. Around the same time, this court held in an unrelated case that the ALJ who presided over Ms. Cochran's case had been unconstitutionally appointed. Ms. Cochran might have thought that would bring her own case to a close, but the SEC chose instead to take a mulligan. In 2018, the agency vacated the initial decision against Ms. Cochran and assigned a different, properly appointed ALJ to retry the case. So 2 years after her administrative proceedings began, they began again. For Ms. Cochran, that was enough. She sued the SEC in federal district court. She sought to enjoin the agency's proceedings on the ground that all of its ALJs are unconstitutionally insulated from presidential supervision, pointing to this court's decisions in Lucia and Free Enterprise Fund. Lucia held that SEC ALJs are inferior officers under the Constitution's Appointments Clause, and Free Enterprise Fund held that the president must retain adequate authority to supervise and even remove such officers. In 2019, the district court dismissed Ms. Cochran's suit without reaching its merits. The court did so because it thought Thunder Basin required that result. A year and a half later, a panel of the Fifth Circuit ran through the Thunder Basin factors and affirmed. A year and a half after that, the en banc Fifth Circuit took another look and largely reversed. Now, more than 4 years after Ms. Cochran filed her complaint, this court balances the Thunder Basin factors anew and holds that her case belonged in district court all along. For its part, Axon has endured a similarly tortuous path. Over the course of 3 years, the district court dismissed its case, and the Court of Appeals affirmed, only to have this court reverse that judgment today. This is what a win looks like under Thunder Basin. When you replace clear jurisdictional rules with a jumble of factors, the room for disagreement grows. The incentive to litigate increases. Years and fortunes are lost just figuring out where a case belongs. Ms. Cochran and Axon have already endured multi-year odysseys through the entire federal judicial system, and no judge yet has breathed a word about the merits of their claims. Nor can I fault the district court in Ms. Cochran's case, or all of the lower courts in Axon's case, for thinking the Thunder Basin factors required dismissal. When we give our lower court colleagues such confused instructions, we guarantee different courts will regularly reach different outcomes on the same facts. Maybe even worse is what Thunder Basin means for others. Not many possess the perseverance of Ms. Cochran and Axon. The cost, time, and uncertainty associated with litigating a raft of opaque jurisdictional factors will deter many people from even trying to reach the court of law to which they are entitled. Nor is the loss of a day in court in favor of one before an agency a small thing. Agencies like the SEC and FTC combine the functions of investigator, prosecutor, and judge under one roof. They employ relaxed rules of procedure and evidence, rules they make for themselves. The numbers reveal just how tilted this game is. From 2010 to 2015, the SEC won 90% of its contested in-house proceedings compared to 69% of the cases it brought in federal court. Meanwhile, some say the FTC has not lost an in-house proceeding in 25 years. That review is available in a court of appeals after an agency completes its work. Hardly makes up for a day in court before an agency says it's done. When a case eventually makes its way to an appellate court, judges sometimes defer to the agency's conclusions, especially when it comes to disputed questions of fact. And how many people can afford to carry a case that far anyway? Ms. Cochran's administrative proceedings have already dragged on for 7 years. Thanks in part to these realities, the bulk of agency cases settle. Aware too that few can outlast or outspend the federal government, agencies sometimes use this as leverage to extract settlement terms they could not lawfully obtain any other way. Like any needlessly unclear jurisdictional test, Thunder Basin carries with it real costs. For individuals seeking to vindicate their rights, for lower courts who deserve better guidance, and for our legal system's promise of a just, speedy, and inexpensive determination of every case. When Congress withholds jurisdiction, we must respect its choice. But when Congress grants jurisdiction to the nation's courts, we must respect that choice too. We have no authority to froth plain statutory text with factors of our own design, all with an eye to denying some people the day in court the law promises them. Respectfully, this court should be done with the Thunder Basin project. I hope it will be soon. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.